G'day friends and foes, I'm Arjay Martin and this is TINLA episode 21. TINLA is short for This Is Not Legal Advice and Nor Is It. How are you all enjoying this lockdown, or as I like to call it, the false imprisonment, unlawful detention, etc. of us all? Unfortunately, I've been hearing stories from friends about their friends suiciding recently, and I don't know how prevalent it is, but it's a terrible thing, and it may well be related to this illegal lockdown. And hopefully society gets back up and running, and basically that we learn not to allow the government to do such illegality, that kind of thing. Now, I've already shown in various episodes of TINLA that the statistics on COVID-19, so coronavirus disease 19, 2019 that is, deaths are greatly over-exaggerated, and there's been a lot of studies come out since using serological reports, which is the type of testing that really should be done. We've already seen the UK ordered testing reagents from China that were actually contaminated with the virus. And, what's the point of that? So, serological report or test tests a blood serum and can basically tell you if there was a previous exposure to the disease, and if there's a current one, so long as the body is fighting it with the traditional immune system, that kind of thing, because there are such things as stealth-adapted viruses that evade the traditional immune system, as an example, and no test is perfect, but the serological tests are a lot better than the other tests that they're doing. That in these previous episodes of TINLA, I've already shown evidence of their inaccuracies. Also, in the USA in particular, they've been doing these serum tests and discovered that there's something like 55 to 80 times the infection going around of the COVID-19 disease. So therefore, there's not 55 to 80 times the amount of deaths. So therefore, the illness is 55 to 80 times weaker in terms of killing people, the mortality rate, than was believed. And that also is on top of the exaggerated deaths from misattribution to COVID-19 being a causative agent, or even being present with certain deaths, because at the moment in the USA, Australia is a bit less transparent, but if someone goes to hospital with a flu-like symptom and dies, that is deemed a COVID-19 death, despite there being no testing for it, and it could well be the flu or pneumonia or several other illnesses. So anyway, in this video I'm discussing, on top of what I've already discussed in TINLA's episode 14, 15, 16 and 17, with episode 16 being the main nuts and bolts of the law that I've provided up till now, which was on the lockdown and border closures mainly. But basically, I'll tell a little story first. So tomorrow is the 10th of May 2020, and it is the 100th anniversary of the birth of one of my grandfathers, and he fought in World War II. He was already in the Royal Air Force as I think it was 16-year-old before the war, but he was apparently very tall, I think maybe 1 meter 86 or something like that, which didn't apparently pass on down the generations so far. But anyway, he was too tall to be a pilot, and I think he was also colorblind, perhaps. But basically, you want short little people to fit in the planes. So during World War II, he ended up as a fitter armourer. He was in the Air Force, the auxiliary, what's it called? The Fleet Air Arm. So basically he was working in the Air Force and was sticking munitions on planes that would then, take off, do their business, and hopefully get back home in one piece. Anyway, so as a part of his service, which was mainly on the HMS Victorious, and I think also the Illustrious as well, but he contracted tuberculosis, or TB as a lot of people know it by, and again, that would be classed as a COVID-19 death in the current situation if it was not tested for and if he died in a hospital. So he died unfortunately at the age of 33 in Concord Hospital, and anyway, he sacrificed his life to fight for freedom, so to speak. So what are you going to do to also fight for freedom? I'm doing my little bit with my little videos and trying to run for Parliament and helping people out, protesting against unlawful draconian laws or purported laws. And one such protest is tomorrow. On my grandfather's 100th birthday, if he was alive for the last 77 years. But anyway, so tomorrow at midday or noon, at every parliament in Australia, so state and territory parliaments, there's going to be a mass protest / exercise sessions. Tai Chi might be a good choice, nice and slow movements so you don't get puffed when the police are there intimidating you, saying, well, you better start exercising if you don't want to call it a protest. And there's nothing saying that you can't protest at the same time as exercising or vice versa either. And that's not a reflection of all police. Hopefully most police are actually great people, and there have been a lot of, some of you would have seen TINLA episode 20 with the nurse coming out in New York stating that basically COVID-19 patients in the 2 hospitals that she was working in have been getting murdered and dying from very, very severe negligence by the doctors and nurses. Not by her, she's trying to do her bit. And there's also been other whistleblower videos from nurses coming out too, saying the same thing, basically that a lot of COVID-19 patients are murdered. But anyway, so luckily there are some police officers now starting to stand up. Again, in America, I've seen an example where there is an officer, G. Anderson, is on his little shirt, and I'll include that video at the end of this video. I think it's a great video, that he's a great man for standing up and not allowing these abuses and speaking out against them, including that, he may well have negative repercussions in terms of employment, in which case he should sue for, unfair dismissal or whatever, I would suggest, if it was me. And of course the USA has different laws than Australia, but, apply it as you see fit. Anyway, so in this video, I've got my computer open here, as you can see in a reflection. It's like a head-up display. And I'm going to go through some other parts of legislation, why these lockdown rules are illegal, invalid, void. Maybe you can get some kind of information from this if you wish to go down and protest or exercise, or walk to get some essential food or whatever via the Parliament, just as further lawful excuses. Not that we need lawful excuses for invalid laws, but this might well save some people a lot of money. Really, all of the fines Australia-wide, COVID-19 fines, I submit are illegal and invalid, void, and they should all be taken to court, in my opinion. And I would do so if I received one. If the courts get flooded, then magically all these fines would probably be dissolved without even needing legal challenges in terms of the constitutionality or validity of the laws and purported regulations, rules, directions by chief health ministers. Anyway, so basically I'll go through a few bits of legislation and some case law and the rest of my 2 cents worth. So I argue that the laws or purported laws, purported rules, regulations, directions by the chief health ministers are invalid for a number of reasons. I'm going to be discussing Queensland law, but most of the laws, especially with harmonised between the states, so basically say the same thing. Sorry about that, I accidentally bumped the touchpad of the laptop. But anyway, you can look up your own laws and apply them to your own state. So basically, grounds, well, maybe I should give like a little roadmap or something, but maybe I shouldn't. But basically, there's certain reasons why the laws are ultra vires, that is, exceeding their powers, that basically, as I said in previous TINLA videos, that there was a so-called social contract between government and people did not give away such power as to create the current situation. They only gave away limited powers for limited purposes, and that is not being complied with. So that's one reason, being ultra vires. 2, there are certain problems with the directions, which I'm about to go through. 3, you can use other lawful excuses such as exercising. Like I said, Tai Chi might be a good option for people. And, if there's little groups of 5 people or whatnot doing Tai Chi at the front of Parliament, then so be it. You can keep your 1.5 meters distance, wear masks if you really want, not for nefarious purposes, but for, the COVID disease that's literally no worse than the flu, as shown by the serological studies in the USA, as well as, the problems with the testing. And the Chief Health Minister does not even have power to issue these directions, I submit. It is also unconstitutional with the federal constitution. And also, what else am I going to discuss? The problem is I'm trying not to just repeat everything that was in my previous videos. So I have to remember what I discussed in those. So another thing is that people have the implied right to political communication. So there have been some people doing little exercise sessions or trying to ask questions and stating to police that they are not protesting. with the government on the news, apparently basically misquoting the law and claiming that people don't have a right to protest, which is illegal, and they should be held accountable for those lies. I don't have a TV, so I miss out on a lot of the propaganda or information. But anyway, sorry about that. The internet cut out, so the video stopped when I went to put the hotspot back on. So this is from the Queensland Health website with the Chief Health Officer Public Health Directions, which is purported rules or regulations that, or really directions, that basically make it that people within Queensland can't do certain things, can't have, friends over to their house if it exceeds a certain number, can't go outside their house unless it's for one of a few listed reasons. You can't go supposedly 50 kilometres from your home, which is completely illegal. I've already covered about section 92 in terms of the intercourse among the states in a previous TINLA video, or a couple of them, so I won't harp on about that one. But anyway, so this is effective from and posted on the 8th of May 2020. Directions from Chief Health Officer in accordance with emergency powers arising from the declared public health emergency using or under the power of the Public Health Act 2005 Queensland, section 362B. So it waffles on and it replaces the third direction because they're easing restrictions when these restrictions are completely illegal. Anyway, so they have that some of the reasons why you can go outside your house. So it says a person who resides in Queensland must not leave their principal place of residence except for and only to the extent reasonably necessary to accomplish the following permitted purposes: to obtain food or other essential goods or services, to obtain medical treatment or other healthcare services, to engage in physical exercise, Tai Chi at the Parliament, whilst you're protesting, perhaps, for recreation within a 50 kilometre radius of the person's principal place of residence, so I think the changes might be in capitals, either that or in bold, I should say, or maybe they just have random bits of boldness, or maybe they're just being bold. Anyway, to perform work or volunteering or carry out or conduct an essential business activity or undertaking, blah, 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 to visit another person's residence in accordance with paragraph 9, which has limits as to how many people you can visit and what times. So from 12:01 a.m. on Sunday, 10th of May, you can have up to 5 visitors from one household who are not ordinarily members of the person's household. So, still can't have birthday parties or anything like that, which is completely ridiculous. It's also oppressive and against social and cultural rights, religion. You might want to have 2 Mormons visit your house. Who knows? Or Jehovah's Witnesses. But they can't. Only one will be able to, unless they happen to live in the same household as each other. Anyway, you can visit terminally ill relatives, attend a funeral or wedding, but no birthday parties. To provide assistance to someone, this is paraphrased, to attend any court or tribunal. So, you can protest at a court or a tribunal and just say, look, under 6 subsection I can do this. Doesn't say what purpose you have to do it. To go to a childcare facility, to attend school, uni, or other educational institution, to assist with or participate in an investigation or any other action by a law enforcement authority, whether voluntarily or not. People under the age of 18 can visit their biological parents or siblings, which is discriminatory anyway, because, you know, if it's an adopted parent, they can do it anyway under federal anti-discrimination laws. But anyway, so, and also another ridiculous thing is it says that if you turned 18, you can't just have this particular exception or lawful excuse or reason. So there's also, these ones are also important. To avoid injury or illness or to escape a risk of harm. So, you know, you are trying to avoid illness by being outdoors, getting the sun, get your vitamin D. It also applies to the medical part and mental illness, because you need friends, basically, social gatherings, because humans are gregarious animals or group loving as opposed to solitary. And then also you're avoiding injuries to your civil rights and liberties. You know, you can be exercising your rights as well as your body at the same time. And to comply with or give effect to the exercise of a power or function of a government agency or entity under a law. So that one's not as powerful. But really you could argue about the power or functions of government can include the right to protest those powers. Anyway, so close that one. So with the Queensland Health Act 2005, under section 362B, power to give directions, this is what those directions were purportedly made under. This section applies if the Chief Health Officer reasonably believes, and it has to be reasonable to everyone, it's not just their idiosyncrasies, but believes it necessary to give direction under this section, a public health direction to assist in containing or to respond to the spread of COVID-19 within the community. The Chief Health Officer may, by notice published on the department's website or in a gazette, give any of the following public health directions: directions restricting the movement of people, directing or requiring people to stay at or in a stated place, requiring people not to enter or stay in a stated place, directing the restricted contact between persons. Again, also I cover, you know, international law or anti-discrimination laws or whatever in mainly TINLA episode 16. So please go and watch my other videos as well, and like, share, subscribe, share this video so it gets out so people are aware of their rights. And if they do get a fine, then hopefully they can fight it. And hopefully they can even, you know, inform the police of the law and not get a fine to begin with. But anyway, and any other direction the Chief Health Officer considers necessary to protect public health, and a public health direction must state the period for which a direction applies, and that a person to whom the direction applies commits an offence if the person fails without reasonable excuse to comply with the direction. So reasonable excuse is, you know, you have legal rights and the right to protest, the right to implied freedom of political communication. Again, I won't go through it in this video. I've gone through it in previous videos, protected by sections 7, 24, 68 and 128, maybe a couple other sections of the Commonwealth Constitution that haven't quite been tested yet or interpreted to apply in that way. But a problem with this is that it is invalid where it states that the health officer may, by notice published on a department's website or in the Gazette, give these directions. In order for a regulation or subordinate law, if you want to call it that, subordinate legislation. Technically, regulations aren't really law, but you know, a lot of people argue against that, but they're wrong, but that's fine. But in order for a regulation to take effect, it must be published in the Government Gazette, and it has not been published. You know, so that's a big issue. And that's based on looking up the 2 Government Gazettes of this month. One was for the 1st of May, the others for the 8th of May, and just quickly going through doing Control F to find anything saying health or direction. I think I looked up one other term, but you know, not solidly read, but I believe it hasn't been gazetted, and that previous direction, number 3, I think was from maybe the 1st of May from memory. Anyway, so that's one big issue. It hasn't been gazetted. Here we go. The previous direction was the 1st of May. So that should be in the 8th of May Gazette, and it does not appear to be in that. So it is of no effect whatsoever, has no force, etc. So now I'm looking up the Statutory Instruments Act 1992, Queensland, and in Division 1 they've got general concepts. Meaning of an instrument is any document. Meaning of a statutory instrument. A statutory instrument is an instrument that satisfies subsections 2 and 3. Subsections 2 and 3 are as follows. The instrument must be made under an act or another statutory instrument or power conferred by an act or statutory instrument, and also under power conferred otherwise by law. So, you know, the law. And the instrument must be one of the following types: a regulation, an order in council, that's from the Governor-General, a rule, a local law, a bylaw, an ordinance, a subordinate local law, a statute, a proclamation, a notification of a public nature, a standard of a public nature, a guideline of a public nature, another instrument or of a public nature by which the entity making the instrument unilaterally affects a right or liability of another entity. However, to remove doubt, as Executive Council minutes is not itself a statutory instrument. Section 8. Just trying to move through the phone here. So, a statutory rule is a statutory instrument that is made by the Governor or the Governor in Council, or that is made by another person or body, but is required by law to be approved, confirmed, or otherwise consented by the Governor by the Governor or Governor in Council, or is subject to being disapproved or otherwise disallowed by the Governor or Governor in Council. I think I did say Governor-General up there when I said about a proclamation, but it's Governor because it's the states, of course. And the meaning of subordinate legislation is Section 9. Subject to subsection 2, the following instruments are subordinate legislation: a statutory rule that is a regulation, rule, bylaw, ordinance, or statute; a statutory rule that is an order in council or proclamation of a legislative character; any statutory instrument including an order in council or proclamation that is declared to be subordinate legislation by an act or a regulation made under this act. So does the Public Health Act actually say that, you know, the directions of the Chief Health Officer is to be a subordinate piece of legislation? Any other statutory instrument that fixes or otherwise determines the commencement of an act or a provision of an act, an instrument or a provision of an instrument mentioned in paragraphs A, B, or C. Subsection 2 is the following instruments are not subordinate legislation: A local law or other statutory instrument made by a local government, a rule, order, direction, or practice of the Legislative Assembly, a statutory rule other than a regulation that is mentioned in Schedule 1A or declared not to be subordinate legislation by an act, or in the case of a statutory rule made under a provision commencing before the commencement of this act, a regulation made under this act. So another point is, it says about the Legislative Assembly, it's a defining characteristic of the Westminster legislative system that you have bicameral or two chambers within the Parliament, and Queensland doesn't have that, going against a referendum in 1917. They abolished it in 1922, doing really dodgy thing, just appointing more Labor people in the upper house, which were appointed, not even voted for back then. And then I'm also going to do another video about section 15 of the Constitution, Commonwealth Constitution, the dodgy referendum that someone, if they were smart, could have referred to in relation to, one House of Parliament, but that's dodgy in itself. So I'll go to Schedule 1A just to see what that says. So statutory rules that are not subordinate legislation, a statutory rule under the Constitution of Queensland 2001, sections 15, 40, 41, 43 or 44, or a proclamation under the Senate Elections Act 1960, section 3. Next we have section 13 of the Statutory Instruments Act 1992, power to do matter by instrument if an act or statutory instrument, the authorising law, authorises or requires a matter to be done, and the matter is capable of being done by instrument, the authorising law authorises the matter to be done by instrument. So another problem is that the subsection B, the matter is capable of being done by instrument. These directions are not capable of being done by instrument. As I said, it doesn't even have a gazette, or it hasn't been gazetted, and there's also other constitutional, as in federal constitutional, reasons why it cannot be done, as well as the other arguments. So, section or subdivision 2, section 21, statutory instrument to be interpreted not to exceed powers conferred by authorising law. So again, what I was talking about, the lockdown laws with and border crossing barriers, restrictions, whatever you want to call it, as per section 92 of the Constitution, which prohibits that. So a statutory instrument has to be interpreted as to not exceed powers conferred by the authorising law. And the state constitutions, of course, are subject to the Commonwealth of Australia Constitution Act as well, and other Australian constitutional law. So a statutory instrument is to be interpreted as it's operating to the full extent of, but not to exceed, the power conferred by the law under which it is made, the authorising law, and distributively. Without limiting subsection 1, if a provision of a statutory instrument would, apart from this section, be interpreted as exceeding power, the provision is valid to the extent to which it does not exceed power, and the remainder of the statutory instrument is not affected. Without limiting subsection 1 of the application, I'm just going to turn the screen down, hopefully my image doesn't go too grainy, but it's hurting my eyes a lot. So subsection 3 was, without limiting subsection 1, if the application of a provision of a statutory instrument to a person, matter or circumstance would, apart from this section, be interpreted as exceeding power, the provision's application to other persons, matters or circumstances is not affected. This section, subsection 4, this section applies to a statutory instrument in addition to and without limiting any provision of the statutory instrument or authorising law. Just quickly scrolling through the next section, because I don't want the video to be too long, but I'll just close it there. Boom. Next, section 31, statutory instruments purporting to be made under a particular power. Purporting means claiming to be, or, having the colour of being made under that particular power in this case. So a statutory instrument is taken to be made under all powers under which it may be made, so it has to be made within the power it can be made, even though it purports to be made under a particular act or another statutory instrument, the authorising law, or a particular provision of the authorising law. So that's sort of like a way to... Sorry, the little Facebook messages started popping up. So that is sort of like a saving feature where, a law could be said to be made under this, but it can't be made under that, but it can be made under this other act. But that does not seem to apply to these directions under which these fines are made. Therefore, if the direction's invalid, then the fines are also invalid. This is very important. This is section 47 of the Statutory Instruments Act 1992. So notification, and this is where, the directions or regulations, rules, whatever you call them, have to be notified in a public gazette for them to be law or to have the force of law. Which apparently has not been done with Dr. Jeanette Young's purported directions to people. So, section 47, notification. Subordinate legislation other than exempt subordinate legislation must be notified by publication on the Queensland legislation website, normal publication of the subordinate legislation and the date of publication. So it also has to be on the Queensland legislation website, which is legislation.qld.gov.au. But it continues, however, if subordinate legislation cannot, for technical or other reasons, be conveniently notified by normal publication, it may be notified alternative publication by publishing it and a date of publication in another way decided by the Parliamentary Council, and normal publication as soon as practicable. Notification of subordinate legislation by alternative publication happens on publication under subsection 2 subsection A. So with the this part's important, but with exempt subordinate legislation, so if the subordinate legislation isn't made by the Parliament, then it is... I think I have this in the next thing, don't I? Then, it can be exempt subordinate legislation as a summary. So the directions are made by the purported power, even though it's ultra vires, without powers or beyond powers, of Dr. Jeanette Young. So I say that it is exempt subordinate legislation, and exempt subordinate legislation must be notified by publication of the subordinate legislation in the Gazette. So it has to be published in the Gazette. And a general rule is anyway, despite whatever this Act says, that in order for, subordinate legislation made by the Parliament itself has to be gazetted to take effect, which apparently has not been done, probably in any state. So here's a Queensland Government Gazette, published Friday 8th of May. And as I said, I've already gone through. So there's 3 instances of health. This, I guess you can say, a lazy way to go through things, but, I can't spend 50 million hours doing each of these videos. I don't even get paid unless you are kind enough to donate some money to me at paypal.me/Arjay Martin. That would help a lot. And anyway, so there's also the 1st of May 2020. Again, so nothing comes up for direction. and health has 3 entries, none of which are relevant. The closest one to being relevant is about a Bill of Parliament assented to, the Appropriation COVID-19 Act 2020, which is not the directions, directions number 3 or 4 that Jeanette Young has purportedly put out. Next we have about invalid laws, putting it nicely, and interpretations of law. So with secondary guidelines to interpretation, I do have a video. It is TINLA 9, which is part 2 about the fake title Queen of Australia. TINLA 1 was the original one that covered half of why the Queen of Australia is an invalid title, but TINLA 9 also goes on about constitutionality, how to determine for a federal level at least if a law is constitutional or not. So I encourage you to please punch into YouTube TINLA 9. And anyway, so as a part of the interpretation of law or the construction of it, there's certain intentions inferred on the Parliament. In interpreting the Act, one of which is that it isn't inferred that the Parliament intended to infringe on fundamental rights, nor in violations of rules of international law that are not domestic legislation. Again, as I keep telling people, even though people want to argue black and blue with me, some people, international law is no law at all unless it is put into domestic legislation. And the one caveat to that is that of interpretation of ambiguous, legislation, which is what that covers. And just got to close that so I can see. So I'll just quickly go through a few little cases. This includes where people were fined thousands of dollars or got fines that could equal thousands of dollars that have been shown to be unconstitutional, invalid, etc. But I'll get to that one in a second. So we've got Kent and Johnson, which was in... So it's in 1972, and I just have to scroll back up. In a federal court. So there was a group of Canberra residents and they were protesting against a telecommunications tower. Apparently it was going to have like a revolving restaurant or something like that inside of it. And the construction relied on the statutes to provide facilities for postal, telegraphic, telephonic and other like services, and the court held that it did not include towers that had restaurants and tourist facilities in it. So it was held that the incidental power was limited because statutory power may not be used for an unauthorized purpose. So these lockdowns are unauthorized, I submit. And clear language is required to authorize activity by a public official that interferes with a fundamental right or freedom or is otherwise tortious. So tortious means a civil wrong, like false imprisonment in the case of the lockdown. So it has to have clear language within the Public Health Act that the chief medical officer, even if she could have these powers, can prevent fundamental human rights. So then you also have Coco against the Queen. That's quite a funny case. in that there was a person who was convicted of bribing a Commonwealth officer, and basically the police or ASIO or whoever it was, I forget off the top of my head, but they trespassed on his property to install a bug in his phone. They gathered evidence illegally with that bug where he was on the phone, allegedly discussing his alleged crime. And basically they had a very clever lawyer who argued successfully that the power to bug someone's phone does not include, or did not include at the time, it's probably changed now, the power to trespass or go on land that would otherwise be a trespass. So they won the case. So it was held again that the Parliament does not intend to interfere with fundamental rights and freedoms unless expressly stated, and limitations on incidental powers. It was held that the power to approve the use of a listening device did not extend to approving the installation of a device by an unauthorised entry onto private premises, i.e. trespassing. From memory, they might even got some money from being trespassed against and had the case thrown out. So quite a clever lawyer, and a lot of people say that lawyers are so bad and whatever, which, someone could argue that that isn't justice if someone did allegedly try and bribe a government official, but, who are you going to call if you have a legal problem, generally, if you don't know the law particularly well yourself. Next, we have a very important case, and that is Evans against the state of New South Wales. A lot of you will remember I think it was 2007, there was a World Youth Day, part of the Catholic Church. So basically a bunch of Catholics came to Australia of school age, and might be, say, under 30 or something, and they were doing marches up and down the streets, which is arguably illegal anyway, under the Bill of Rights that Australia did inherit, and other legislation, but again, that's another video. But there were laws purportedly made, by the Yema government. Morris Yema was the Premier of New South Wales, and they made laws saying that you could not annoy, harass, that kind of thing, the Catholics, which, people should have respect for other people. But what ended up happening was there was a protest group that was called the No Pope Coalition, and they were going around handing coat hangers and condoms to Catholics during the march, apparently, and had shirts saying like Pope Go Home, something like that. And they were fined. The fines, I think, were up to $5,500 or $3,500. I forget which. I might have it open somewhere. But anyway, they challenged the constitutional validity of the state legislation and successfully won in a federal court. And basically, because they have the right to political communication, that they had the right to do that. So they were making political statement, doing a protest against, Catholics, generally speaking, don't support birth control. So the condoms and the coat hangers were symbolising that people in olden days apparently used to wind up coat hangers and pull a baby out to kill it that way instead of doctor done abortions. But anyway, so they successfully won. So again, the Parliament does not intend to interfere with fundamental rights and freedoms unless expressly stated, and the High Court declared that the Regulation 7 was invalid and held that Parliament is presumed not to intend to alter common law or interfere with fundamental rights and freedoms unless clearly stated to the contrary. And even if they did state it to the contrary, they could have lost anyway. So there's also another example where New South Wales Police watchdog finds strip searches of 4 teenagers at music festivals were unlawful. This is an ABC News story by Belinda Contaminas. And it goes through that a 16-year-old girl was left completely humiliated at a Byron Bay Music Festival when she was strip searched, which was unlawful according to New South Wales Police watchdog. Squat at Splendour in the Grass in 2018 after a sniffer dog sat next to her. She couldn't stop crying. She was completely humiliated. So this involves the Law Enforcement Conduct Commission, LECC, and they handed out findings, even though they aren't a court, but still, that strip searches of 3 teenage boys between ages of 15 and 17 at the Lost City Music Festival at Homebush in February 2019 were also illegal. One of the boys was told by a police officer to hold your DICK and lift your balls up to show me your gooch, whatever gooch is. Another boy was strip searched by an officer who made contact with his testicles while not wearing gloves. You know, how many of these police officers are potentially not in a right frame of mind to be doing strip searches? I'm not saying these ones in particular, but how many, predators are there basically that could well abuse their power? Which I'm not suggesting that these particular officers were. Anyway, so then you got Courtbacks WYD activists, that's World Youth Day, activists right to annoy. 2 student activists had won a court challenge to special World Youth Day laws that allowed police to detain people or fine them $5,500 for annoying or inconveniencing Catholic pilgrims. So the No to Pope Coalition, Amber Pike and Rachel Evans, I wonder if they are in politics now or something. They argued that the laws were unconstitutional in a federal court because it made their peaceful protest illegal. And they won. As a summary. So that's a little story posted 15 July 2008. It doesn't say an author, which is a bit surprising. Again, on the ABC website, you can look up Courtbacks WYD activists right to annoy. Also have a gentleman here wearing Pontifex me vecat, which apparently is Pope go home. 11 commandments, greed is good. 11th commandment, greed is good. So obviously about the Catholic Church being zillionaires and also not having to pay tax. In which case, if people only pay tax in terms of businesses or corporations if they are profitable. So really should charities have tax exemption statuses, which also applies to wages and whatever as well. Maybe, maybe not. If they're not being profitable, then they're being charitable. Ensure that, charities have to save their money and grow and expand and invest, but that's beside the point. And then another shirt says, we put it on down under, and this shirt is anything, and then I can't read the rest of what it says. This article's the 9th of July 2008, says, or it's entitled, a member of the Catholic World Youth Day protest group No to Pope Coalition holds up t-shirts. And I am finally going to make a little t-shirt stall where it is drop shipped or fulfillment process where, you know, I put some logos on t-shirts and you can order them, and it goes through a third party, the one that prints it and whatever. I have looked over the past few years for different Australian made shirts that, you know, we could do t-shirts and hats and whatever as well, but unfortunately we were unable to do so. I was going to make a t-shirt since about 2008 or something like that, but I never got around to it with a friend, and then later on with my ex, who wasn't my ex at the time, in 2011. But, you know, finally going to do that now. So I'll put a link in the description, and just be like a little sample shirt at first, which you can order, but then expand from there. And, you know, that's one way you can also support, one, advertising, and two, me making these videos, as well as donating via paypal.me/Arjay Martin. Next we have, what about move on laws? So, you know, the police can tell you generally, so the belief is, to move on. So even if they accept the argument that these directions are not lawful, then they can still say, well, you got to move on anyway. Just a second. Oh, nose going itchy. So, using the Queensland Police Powers and Responsibilities Act 2000, Queensland, move on orders is under Part 5. I can't really scroll up and see which division at the moment, or Chapter 2, Part 5, because how I'm holding the phone against the screen to record, try and keep it stable. So with directions to move on, it applies in the following places: public places, including a public place in a safe night precinct, and prescribed places that are not also public places. The part under section 45 does not apply to authorised public assemblies, and if, you know, people are going to be arrested in Queensland at the Parliament tomorrow, then, you know, I can put in for an authorised public assembly, even though the requirement is invalid constitutionally, I argue. So when the power applies to behaviour, a police officer may exercise a power under section 48 in relation to a person at or near a regulated place if the police officer reasonably suspects that the person's behaviour is or has been, and it's got the listed reasons, causing anxiety to a person entering at or leaving a place, reasonably arising in all the circumstances. Reasonable means it's not up to, you know, Joe Blogg's police officer's discretion. It has to be in accordance with a reasonable person, which is really the decision of the court, what they think is reasonable or not. So it's not subjective, it's objective. Interfering with trade or business at the place by unnecessarily obstructing, hindering or impeding someone entering or leaving a place. So the Parliament's going to be closed on a weekend anyway, so whoever's entering is kind of a moot point, because there's probably not going to be anyone entering. But of course, you know, people should protest peacefully and not obstruct people, that kind of thing, and then you can't get a move on direction. Disorderly, indecent, offensive or threatening to someone entering or entering at or leaving the place. Again, you know, we're just doing peaceful exercises of our rights and liberties and bodies, if you want to use that as a secondary excuse or a primary one. Disrupting the peaceful and orderly conduct of any event, entertainment or gathering at the place. G'day, the phone ran out of memory that time. We need to get some external hard drive or something. But as I was saying, the police disrupting the peaceful and orderly conduct of any event, entertainment or gathering at a place means that they should issue themselves a move on direction. There's also a part for prostitution and whatnot, but that's obviously not applicable. And I'm just trying to quickly go through. Turns out the computer's out of memory as well. So under the Peaceful Assembly Act 1992, a person can apply for an authorised protest, and that comes with certain protections as well. Legal immunity for participants in public assembly under Section 6 as an example. It also says that you have the right to peacefully assemble, that kind of thing, and so long as you aren't like obstructing people's businesses or whatnot. So as I said, I can apply for an official protest next week, say, if they have problems in Brisbane tomorrow. Also quickly, as I've said before, with the Australian Communist Party against the Commonwealth, you have Fulliger saying that a power to make laws with respect to lighthouses does not authorise the making of a law with respect to anything which is, in the opinion of the lawmaker, a lighthouse. A power to make a proclamation carrying legal consequences with respect to lighthouses is one thing. A power to make a similar proclamation with respect to anything which is in the opinion of the Governor-General is a lighthouse is another thing. We also have the gates part of that decision, and also that the government cannot recite itself into power and a stream cannot rise above its source. We also have the 1942 first tax case, or first uniform tax case I should say, which is South Australia against the Commonwealth. And when I have to restart the computer, it lost all my bookmarks, unfortunately. But I did discuss this in TINLA 16 anyway. Basically, an invalid law is invalid from the beginning. It doesn't require a court to deem that it's invalid, that anyone is entitled to disregard it. We also have Georgie Ardis against the Australian and Overseas Telecommunications Corporation, which is presumably Telecom's old name, or Telstra's old name. And within that, it's stated, it is often said in relation to constitutional guarantees and prohibitions that you cannot do indirectly what you are forbidden to do directly. That maxim is in fact an important guide to construction or interpretation of legislation, indicating the guarantees and prohibitions are concerned, or that guarantees and prohibitions are concerned with substance, not form. So it doesn't matter if the government says, hey, look, we've done XYZ in XYZ form, that the substance is what matters. Again, with the communist case, that applies as well. Some people doubt that the Constitution applies to them. The Commonwealth Constitution, that includes often a lot of magistrates and, I guess you can say, judges as well. Magistrates, courts, local courts, and potentially beyond. Because, you know, some people get told this is a local court or this is a magistrate's court. It's not a high court. We have nothing to do with the Constitution. That's just completely false. As per covering clause, really section 5 of the Constitution, operation of the Constitution and laws, this Act and all laws made by the Parliament of the Commonwealth under the Constitution shall be binding on the courts, judges, and people of every state and of every part of the Commonwealth, notwithstanding anything in the laws of any state. And of course, for the part about laws made by the Parliament of the Commonwealth, they have to be valid laws as well. Next we have in section 51 we have subsection 9 on quarantine. As you'll see for subsection 7, they have lighthouses, lightships, beacons and buoys. You also have subsection 6 about the naval and military defence of the Commonwealth. So obviously, concurrent powers, some of them aren't concurrent anyway, because states can't control military and whatnot. And also, as you'll see in a second. Sorry, I'm losing my voice. Section 69 of the Constitution, which is a lot of people's favourite section. On a date or dates to be proclaimed by the Governor-General after the establishment of the Commonwealth, the following departments of the public service in each state shall become transferred to the Commonwealth. Post, telegraphs and telephones, so postal services, etc., as I already said. Naval and military defence, lighthouses, lightships, beacons and buoys, quarantine. But the Department of Customs and of Excise in each state shall become transferred to the Commonwealth on its establishment. So quarantine, which is quarantine type laws in substance. These lockdown laws and border restrictions, and you can't travel 50 kilometres from your home, are part of quarantine, and quarantine was transferred completely to the Commonwealth Government. In the commentaries of the Constitution of the Commonwealth of Australia, aka Quick and Garron's annotated Constitution, I'll just have to quickly refine this. Lighthouses. So if you type lighthouses in a searchable version, which I can include in the description or whatever, go to the third mention, and it's got paragraph 170, lighthouses and co. These works and services will be taken over from the states on a date or dates to be proclaimed by the Governor-General after the establishment of the Commonwealth, section 69. Fortunately, as I said, I lost my little bookmark, so I'm just seeing if I just skip to the next one. The fourth mention is about transfer of certain departments, and then it repeats, basically. Asian boys. Anyway, because I'm running out of room on both the phone and the computer, I'll just try and be very quick. So basically it does say in here, which this might be the right part here. Basically, I don't have time to reread it and refine the bookmarks because the protest is, tomorrow in 13, 14, 15 hours by the time you watch this, because I do have to render it and upload it to the internet as well. So that might take an hour or two. But anyway, this might be it. Oops. Basically says that all of the departments and the officers of the departments are transferred to the Commonwealth, and the states aren't supposed to deal with those things anymore. Here you go. So paragraph 353, all officers of the department, where the department transferred is a whole of one of the great political departments, as for instance the Department of Post, Telegraphs and Telephones. The interpretation of the term all officers presents no difficulty. It evidently includes every officer, whatever his tenure or the nature of his employment, from the permanent head of the department downwards, but not, of course, the political head, so, not the minister for telephones or whatever. When the department ceases to exist as a state department, the ministerial portfolio established by the state in connection with it must also cease to exist. So you can't have a minister for telephones when telephones have been transferred, as an example. I.e., you can't have a quarantine department or quarantine being dealt with by the state governments after it's been transferred. And where the department transferred is a sub-department, as for instance the Department of Quarantine, it seems that only those officers who are exclusively officers of the sub-department will become subject to the control of the Commonwealth. So just say if there was a Department of Health and that included quarantine, then the quarantine part is cleaved from the Department of Health and removed from the states to the federal government, then it can no longer obviously come back but then, the managers or whatever and staff of the quarantine section of the Ministry of Health or Department of Health are transferred or were transferred to the federal government, but not, the chief medical officer, as an example. But therefore, I argue that the states can't even have quarantines. They can administer federal quarantine law, of course, with full and frank credit, blah, 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 but that's a different thing. So that'll probably do for this video. I hope it's enjoyable for you, that you learn from it, that it saves a lot of people getting a lot of fines, that it helps break the illegality that exists in the current society with these lockdowns. I repeat that the lockdown protest / exercise sessions / whatever you want to call them are at midday on the 10th of May 2020 at every state parliament and territory parliament house. Also, hopefully it can be a worldwide protest. You have the Americans and Germans out on the streets in particular, having a go, having a protest, and good on them. It'd be great if Australians, more of us, weren't just interested in, things that don't really matter, like, arguably sports or whatever so much, or sports scores and statistics, and, spent the time or the extra time you've got now with the lockdown to actually look into how the government works, to protest, that kind of thing. If this saves you any money in terms of you get a fine and the fine disappears, or you fight the fine, something like that, or for any other reason, please consider me and donate some money for helping. I'm not providing legal services, so it's not a charge for legal services, it's just a donation if you appreciate my work. And thank you. Please watch this video with the US police officer standing up and, standing up for the rights of not only police officers but the civilians' rights. And here's a great example of how awesome police often are. And hopefully more police officers worldwide follow his guidance and his leadership in coming forward. Thank you. Bye. Woo.
As a police officer, I'm compelled to make this video. I've been in law enforcement for 10 years, and I'm speaking to my peers, other fellow officers, people in any kind of law enforcement position. I've seen officers nationwide enforcing tyrannical orders against the people, and I'm hoping it's the minority of officers, but I'm not sure anymore, because every time I turn on the television, Every time I look to the internet, I'm seeing people arrested or cited for going to church, for traveling on the roadways, for going surfing, opening their businesses, going to the park with their families, or doing nails out of their own house, using their own house as a place of business, and having undercover agents go there and arrest them and charge them with what? With a crime? I don't know what crime people are committing by doing nails in their own house, but we're seeing this more and more and more, and we need to start looking at ourselves as officers and thinking, is what I'm doing right? Now, I want to remind you that regardless of where you stand on the coronavirus, we don't have the authority to do those things to people just because a mayor or a governor tells you otherwise. I don't care if it's your sergeant or your chief of police. We don't get to violate people's constitutional rights because somebody in our chain of command tells us otherwise. It's not how this country works. Those are de facto arrests. You know, we're violating people's rights and taking money from them, or even worse, arresting them and depriving them of their freedom when they are exercising their constitutional rights. So let's talk about that. Let's read something right here off of the Declaration of Independence. All men are created equal. Among these, we have the right to life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their power from the consent of the governed, meaning our power and any government official's power is derived from the people. Okay? We don't hold power over our citizens. It's contradictory to everything that our country stands for. And this is what I'm seeing. First Amendment rights, telling people they can't go to church, freedom of religion. Okay? Telling people they can't protest, freedom of assembly. Fourth Amendment violations, illegal traffic stops to check for papers. What are you, the Gestapo? Is this 1930s Nazi Germany? You don't get to stop people unless you have reasonable suspicion or probable cause that they have committed a crime. And I know people that have personally been stopped saying, we want to see papers showing that you're essential.
David 2, copy a phone call.
That is not how our job works, okay? What really has been pissing me off lately is the fact that these officers that are going out here and enforcing these tyrannical orders, what they're doing is they're making my job and my safety, or they're putting my job and my safety at risk. Because what you're doing is you're widening the gap between public trust and law enforcement officers. And what that's going to do is it's going to, I mean, look at what's happened to law enforcement in the last 10 years. Less and less public trust, and more often than not, that is a result of isolated incidents that get blown out of proportion. They're not isolated anymore. They're happening every single day. And the thing that I want you guys to realize is that our power that we hold as law enforcement officers is nothing more than a facade. It's a badge and a gun. And people, you don't realize, if you haven't lived in anarchy, if you haven't seen combat, things can be stripped from people in a heartbeat. And that's what I'm afraid of. I'm afraid that these actions are going to wake a sleeping giant, i.e. the American people, okay? They are going to be put in a position where they won't have their rights trampled anymore. And us as law enforcement officers, we'll have our ability to enforce the law stripped from us in about 10 minutes, okay? I think what is going to happen if this continues is we're going to see bloodshed in the streets, okay? I don't want to see bloodshed in the streets on either side of this coin. I don't want to see fellow officers get injured or killed, and I certainly don't want to see citizens get injured or killed. And I promise you, most of you out there doing these tyrannical acts against our citizens, you're not ready for combat. You're not mentally or physically ready for combat in the first place. I promise you, you don't want to go through that. And I hope I never have to go through that again. You don't get to just say, well, I'm doing this because I was told to do so, or I'm following orders, or I need to keep this job. Guess what? I need to keep this job more than anybody. I have 3 young children. I have 2 houses. Like, I have the same sob story that the rest of you guys have. But my personal choices and my living arrangements, no matter what they are, don't allow me to trample on people's rights. And I don't understand why that concept is so hard for people to understand. Listen, you need to stand up for what's right. You need to, if you're part of a department or an agency that is asking people or asking their officers or their deputies to impose on people's rights and infringe on their freedoms, you need to step up and say, no, that's not me. That's not what I signed up for, and that's going against my oath. And if that costs you your job, so be it. At least you'll be able to look at yourself in the mirror at night. I've already expressed this to my department. And luckily for me, I come from a department that I feel like my chain of command shares my view, but I don't care what department you're part of or what your chain of command thinks. You don't get to trample on people's liberty. And so, as a special operations veteran, I've fought on the streets of Iraq under the U.S. government's guise of freedom. And I'm telling you what, the American people are going to you are going to wake a sleeping giant, and they are going to fight 10 times harder for their freedom on their soil than anything you've ever seen before. And if that's something you're willing to face, then keep trampling on people's rights. But I promise you, the American spirit of defiance is going to rise again, and it's going to be a big problem for our country. So I'll leave you with this, something that I learned as an E-nothing in the Army. No matter what situation you're put in, if you look inside yourself and ask yourself one question, am I doing the right thing? You ask yourself that, you know the answer. And no amount of money or no order or law or anything should be able to make you go against doing the right thing. So I'm imploring officers to look inside themselves and ask themselves, is this what I want to be doing to my citizens? And I think the answer is clear. And if we all stand up together, guess what? It'll be a non-issue, no factor, because people and law enforcement will be united like we should be.